7 justices of the United States Supreme Court issued an emergency ruling in the middle of the night. Waking up unaware that it happened is not a coincidence. That is part of how the political system operates. Those whose power was reduced have every reason to ensure confusion, distraction, or a lack of information. But the Supreme Court, 72 emergency ruling, did more than resolve a legal dispute. It altered how power flows in the United States. It changed the rules of the constitutional framework. You deserve to know exactly what happened, what it means, and why institutions from the White House to the Department of Justice are struggling to manage a story they cannot control. To grasp the impact of the Supreme Court's decision, first understand the mechanism it dismantled. Nationwide injunctions had become powerful tools over the last several decades. They were legal weapons used by both political parties whenever the democratic process produced results they opposed. The process was simple. If your side lost in Congress, the legislation failed. If executive action passed, or an election did not favor your side, democracy demanded acceptance. Losing meant rebuilding arguments, building coalitions, persuading citizens, and trying again. That is the foundation of self-government. Yet both parties discovered a shortcut that bypassed this system. They found federal judges in districts where ideology favored them and filed lawsuits. The cases did not need to represent the entire country, just enough to secure a nationwide injunction from a single judge. Once issued, these orders froze laws, policies, or executive actions for every American, pending lengthy litigation. One unelected judge could halt national policy for hundreds of millions of people. That is not a legal remedy. It is a policy veto wielded by someone answering to no voter, often placed strategically for that purpose. The Supreme Court, with 7 votes, ended that practice. The key legal issue is the scope of injunctive relief. When a court sides with a plaintiff, how far does the order extend? Does it only protect the plaintiffs, or does it cover the entire country? The Supreme Court ruled clearly. Relief must be tailored to the actual plaintiffs. Remedies must match the specific harm. One lawsuit cannot create national policy affecting everyone. The court's order must correspond to the injury. One district judge cannot wield the power of a legislature. This principle had been ignored for decades by both parties. They criticized overreach when the other side did it and stayed silent when their side benefited. The Supreme Court clarified that the quiet exploitation ends here. This ruling also highlights the separation of powers. Nationwide injunctions are not just procedural issues. They undermine constitutional balance. Courts are meant to resolve disputes, not legislate or set policy. When one judge blocks laws or executive actions for the entire country, the judiciary ceases to be a check on power and becomes an exercise of power itself. 7 justices drew that line in an emergency ruling. Emergency orders are rare and reserved for constitutional crises. Lower courts issuing nationwide injunctions had become routine, normalized, and exploited efficiently by advocacy groups, state officials, and administrations seeking to block policies without legislative approval. This emergency ruling came after observing patterns where multiple states challenged federal agencies over exceeding constitutional authority. The states were presenting serious constitutional arguments. They challenged regulatory overreach, accused federal agencies of rewriting laws through executive directives, and argued that emergency powers were being used beyond anything authorized by Congress. These were not fringe claims. Constitutional experts across multiple ideological positions have been raising the same concerns for years. When states brought these cases into federal court, the lower courts answered with nationwide injunctions that blocked state laws entirely. Pause and consider what that means. States argued that the federal government exceeded constitutional authority, and the federal court system reacted by shutting down state laws before full hearings even took place. If that does not resemble a system disconnected from its stated purpose, it is difficult to explain what would. The Supreme Court recognized it immediately. That is why 7 justices acted in the middle of the night. This was not an accident. It was a structure functioning exactly as the most aggressive actors in American politics had designed it to function. The wording inside the ruling deserves close attention because it extended far beyond procedural law. It became an assessment of what has gone wrong in American governance. Justice Neil Gorsuch issued a concurring opinion. He agreed with the majority ruling, but believed the constitutional principles involved were important enough to address separately. One line from his opinion is already being quoted by legal scholars and constitutional attorneys throughout the country. Gorsuch wrote that lower courts using broad nationwide injunctions were acting like miniature legislatures. That statement carried enormous weight. A sitting Supreme Court justice looked at federal district courts and argued they were no longer behaving as judges, but as unelected lawmakers, imposing nationwide policy on 300 million Americans through lawsuits involving only a handful of plaintiffs. Gorsuch pushed the point further. He argued courts must return to the traditional limits of equitable relief. In other words, judicial remedies should remain proportional to the harm suffered by the actual parties in the actual case. The logic was straightforward. If one person suffers harm, a judge can order that harm to stop, But a judge cannot use a single plaintiff's injury to regulate conduct toward every citizen in the nation who is not even before the court. That is not justice. That is policymaking. And in a constitutional democracy, policy belongs to institutions accountable to voters, not federal courtrooms where no ballots are cast. Justice Sonia Sotomayor, one of the two dissenting justices, raised a concern that the majority acknowledged but rejected. She warned that limiting nationwide injunctions could create a fragmented legal system. Laws could remain active in some states while blocked in others. Some Americans could receive legal protection while others would not, entirely because of whether they happened to be involved in a lawsuit. That concern is real. Uneven enforcement of laws is a real issue. Rights existing in one zip code but not another is also a real issue. The dissent identified that clearly. But the majority concluded that the alternative posed a greater danger. Allowing a single district judge to freeze policy for the entire nation creates another form of inequality. Outcomes then depend less on the merits of a case and more on which courthouse receives the filing and which judge oversees it. That structure had been aggressively exploited by powerful interest groups armed with creative legal theories and strategically chosen jurisdictions. The Supreme Court declared that practice over. If Congress now wants consistent national standards, then Congress must create them. That is the responsibility of elected institutions. At this point, the debate moves beyond legal theory and directly into everyday life in 2026 America. The effects of this ruling will spread quickly into every major policy arena. Immigration is the first example. For years, immigration enforcement has been shaped by nationwide injunctions. Travel restrictions under the Trump administration were frozen through these orders. Deportation priorities and enforcement rules during the Biden administration faced the same treatment. Under the Supreme Court's new framework, that cycle becomes far harder to maintain. A state can no longer have its entire immigration enforcement structure halted because plaintiffs in another state filed suit under completely different circumstances. The immediate result is that immigration policy will increasingly have to be decided through Congress, state legislatures, and democratic institutions, rather than through courtroom maneuvers neither side was ever entitled to use. The same shift applies to firearms policy. In recent years, several states approved major gun regulations, including expanded background checks, red flag laws, and restrictions involving certain weapons. Many of those measures were challenged in federal court and blocked nationwide before they could even take effect. That legal dynamic has now changed dramatically. States passing gun laws will have far more room to enforce them while cases move through the courts. No matter which side of the gun debate someone supports, the battlefield has shifted. The courtroom shortcut is disappearing. Changing gun policy now requires winning elections and passing legislation. That is not a side effect of the ruling. It is the central purpose behind it. Election law stands next in line. Voting rights disputes, voter identification requirements, absentee ballot rules, and redistricting battles have all moved through federal courts using nationwide injunctions to impose sweeping blocks. The new ruling makes it much harder for one lawsuit to freeze election laws across the country. As a result, election policy will increasingly be determined in state legislatures and Congress through direct political contests, rather than through strategic judicial filings. Environmental policy is also affected. Clean power plants, methane regulations, water protections, and endangered species enforcement have all been targets of nationwide injunctions from both sides. That legal tool is now far less available. Anyone focused on environmental enforcement must now look primarily toward the legislative branch. Courts can no longer substitute for congressional action. The Supreme Court effectively made that principle official constitutional law. The political fallout began immediately after publication of the ruling and continues accelerating. The White House and the Department of Justice both issued carefully restrained statements. Neither praised nor condemned the decision. Both simply stated they were reviewing the order. That language reflected institutions trying to assess the scale of the damage before responding further. Inside the DOJ, officials reportedly described the ruling in private conversations as a legal earthquake. That description was deliberate. It was not accidental, and it was not exaggerated. For years, the Department of Justice treated the federal court system as an extension of executive authority, relying on nationwide injunctions to defend and reinforce federal agency actions that likely could not survive a true legislative process. This Supreme Court ruling changes that operational structure at its core. At the same time, state attorneys general moved immediately. Within hours, legal teams across multiple states filed supplemental briefs in ongoing litigation, directly citing the Supreme Court decision as constitutional support for arguments against federal overreach. These responses were not improvised. They had already been prepared and were waiting for precisely this kind of signal from the highest court. State attorneys argued that the Supreme Court had confirmed what they had maintained from the beginning. States still possess the authority to defend their sovereignty and enforce laws passed through democratic processes without facing blanket freezes. imposed by federal judges, substituting personal policy preferences for the decisions of elected legislatures and the citizens who voted for them. One reality remains largely absent from mainstream coverage. This ruling does not belong to a single political party. In the current political climate, the states most energized by the decision are generally Republican-led states challenging Biden-era and Obama-era federal policies. But the pattern has reversed before, and it will reverse again. When Democrats control the White House, Republican attorneys general race into federal courts seeking nationwide injunctions against progressive federal actions. When Republicans control the White House, Democratic attorneys general use the exact same strategy in the opposite direction. Both parties mastered this system. Both benefited from it. Both condemned judicial overreach whenever injunctions harmed them, and both stayed silent when those same injunctions served their interests. The Supreme Court, through a 7-2 ruling, told every faction across the ideological spectrum that the practice is over. If political leaders want to shape national policy, they must win elections, form coalitions, persuade voters, and pass legislation through democratic institutions. They can no longer manufacture nationwide outcomes simply by filing lawsuits in favorable jurisdictions before sympathetic judges. That era ended with a 7-2 vote. The broader significance of this decision stretches far beyond immediate legal consequences. The Supreme Court did not simply limit lower courts. It forced the country to confront a deeper question both parties avoided for decades. What is democracy actually supposed to look like in the United States? For years, both political parties quietly accepted the growing power of the federal judiciary because it was strategically useful. It allowed political actors to achieve national policy victories without governing, without securing congressional majorities, and without persuading the public. Instead of passing laws, they searched for the right judge. That institutional dependence transformed the judiciary from a constitutional check into an active exercise of power. Courts increasingly operated like unelected policymaking institutions, accountable to no voters, and responsive mainly to those with the strongest legal teams and the most favorable jurisdictions. This emergency ruling is not the final word on the issue. The underlying cases now return to lower courts, which must apply this narrower framework to specific disputes. Those courts will operate under intense scrutiny, fully aware that broad nationwide injunctions without strong constitutional justification could face immediate reversal from the Supreme Court. The federal government will likely search for test cases where it can argue that national interests and constitutional stakes justify broader relief under the revised standard. Circuit court divisions will also emerge as appellate courts interpret the ruling differently. Those conflicts will eventually force the Supreme Court to revisit the issue with an even deeper constitutional examination. This marks the beginning of a long legal recalibration, not the conclusion of the debate. Yet one thing will not return to its previous form. Through a 7-2 supermajority, the Supreme Court publicly declared that using nationwide injunctions as political weapons is constitutionally illegitimate. That declaration changes everything. Lawyers will advise clients differently. Advocacy groups will redesign legal strategies. Federal agencies will calculate risk differently before issuing regulations. States will reassess their legal exposure when passing controversial laws. The entire structure of American legal strategy shifted with this decision. The deeper implication is straightforward. American democracy may now be forced to function more like an actual democracy. That process is slower. It is more difficult. It is often messy. It produces outcomes that frustrate every side of major debates. Because that is how democratic governance operates when functioning as intended. Compromise becomes necessary. Negotiation becomes unavoidable. Accountability returns to the center. Political movements must continually persuade the citizens who ultimately hold power in a self-governing republic. Courts cannot replace political legitimacy. 7 Supreme Court justices made that constitutional reality unmistakably clear. The next chapter of American legal and political history will depend on how institutions respond. Will Congress create clearer and more consistent legal frameworks so the absence of nationwide injunctions does not create the fragmented system Justice Sonia Sotomayor warned about? Will state legislatures engage more carefully with constitutional limits? Will federal agencies become more disciplined and more firmly grounded in statutory authority when issuing rules and enforcement actions? Or will political actors spend the next decade searching for new loopholes, new shortcuts, and new jurisdictional strategies to bypass the limits the court just imposed? The Supreme Court can draw constitutional boundaries, but it cannot force anyone to respect them. That responsibility belongs to voters, citizens, and the officials they elect to write laws, appoint judges, and govern the country. This 7-2 emergency ruling stands as a historic turning point. Not because every issue was resolved. It was not. Not because every abuse ended. That was impossible. But because 7 justices examined a corrupted system directly, decided enough was enough, and used one of the most powerful tools available to the nation's highest court to push the United States back toward the constitutional republic it was designed to be. Whether that correction lasts, whether it becomes a genuine structural reset or merely a temporary pause before another cycle of institutional games, depends entirely on what happens next. In legislatures, in elections, in courtrooms, and in the public understanding of what the Constitution actually says and what kind of government it establishes, that is the full significance of what just happened. This is not a story that disappears after 72 hours of headlines, partisan arguments, or social media outrage. The impact will matter in 5 years. It will matter in 20. Stay informed. Share this discussion with others who need to understand what is unfolding inside the American constitutional system. Keep the conversation focused on facts, law, and the long-term consequences shaping the future of the country.